Now, Chairman Goodlatte had asked you about the recommendation, and you talked about the briefing team, and you said you saw no reason not to accept the recommendation of the team. How much time did you spend reading the recorded testimony of Hillary Clinton from that 3.5-hour interview?
Congressman, I'm not going to go into the particulars of my briefing, except to say that...
No, this is just your own personal work. Did you go through in detail all of the statements she made in that 3.5-hour interview?
Congressman, as I've indicated previously, my role that I had decided earlier was that I would be speaking and meeting with the team who had done that substantive in-depth work for over a year, that had worked on this matter, that had compared the facts and the evidence.
Now, you've said that several times, Attorney General, and I don't have enough time to have you keep repeating that 4 more times. But when Chairman Goodlatte asked you about the statute and whether it includes the term gross negligence, you made an improper statement. You said discussion of the statute would require discussion of the facts. That's not true. You know, from my years of judging on the bench, your comment that discussion of the statute would require discussion of the facts, when he asked you about an element that's contained in the statute, Attorney General, that really sounds like an answer somebody would give who hadn't read the statute and was looking for a dodge to avoid talking about a statute with which they're not familiar. You are aware, and this doesn't require any discussion of any facts whatsoever, but you are aware that in 18 U.S.C. 793F, gross negligence is an element of the offense, are you not?
Congressman, I refer you to my statement that you just commented on with respect to my answer to the chairman.
Okay, well, if you're not going to answer the question, I'm afraid you may be
reinforcing it. Question to me was the meaning of a phrase.
Now, you said there was no basis not to
manner.
accept the recommendation of our team, but you've given no indication whatsoever that you did any independent reading of the evidence, of the statements. Was Hillary Clinton's statement even recorded?
Congressman, I'm not going to discuss the specifics of that. I believe the FBI has provided extraordinary clarity and insight into that.
Okay, well, if you're not going to answer the question, then let's move on. But I find it extraordinary that after a 3.5-hour interview, so quickly a recommendation is made. So there are inquiring minds that are very intelligent that have said, wow. It almost sounds like on that plane, somebody said, look, if you just tell Hillary to come in, we're wrapping up, but we got to be able to say that we interviewed her. It won't be recorded, so she'll be good. It sounded like it was a check the box. You're familiar with Scooter Libby's case and Martha Stewart's case. I know it was well before you came to office, correct? You remember they were prosecuted for making a false statement when the FBI and the Justice Department couldn't make the case they started out. You remember that?
One in New York and I believe one here.
Right.
Here meaning DC,
and so that's a pretty common instrument to be used. If someone makes a statement somewhere inconsistent in what they tell the FBI, that itself becomes a matter of prosecution. And I am shocked. I thought it would be weeks before an answer could be made, but it looks like to do a 3.5-hour interview, you haven't reviewed the facts, you reviewed the team recommendation, and I would just encourage you, Attorney General, your oath was not to follow the recommendation of some team. Your oath is your own responsibility to our Constitution and those that are working under you. My time's expired.
Chair, thanks. The gentleman.